Welcome back to Nairobi Legal Insights. In this video, I explain the legal risks related to negotiations, particularly emphasizing obligations before you enter into obligations. And this is in the context of negotiation and the whole idea of actually entering into legally binding contracts. As you enter into a negotiation, there are two key important things that you must have at the back of your mind as far as obligations are concerned. And the first question you need to ask yourself is whether you're carrying any liability during the negotiation process, meaning that are you able to break off these negotiations without actually carrying any liability as you go about your negotiation. The next important point is whether you enter into obligations unnoticed, meaning that you could be negotiating with another party, but in the process, you could actually be entering into obligations without knowing. For example, this would depend on the amount of information that has been disclosed, and some of that information could be protected information. So to what extent can you then say that after this negotiation, I'm free to break off this particular negotiation, or actually that particular negotiation becomes binding onto you because certain classified or information that is protected was disclosed during that particular setting. To fully understand obligations before entering into obligations, it is also important to consider the jurisdiction in which you're operating as you go into that negotiation room. For example, when it comes to the common law system, it is easy to break off from negotiations anytime because this particular system is permissive, meaning that you can choose actually to walk away from the negotiations. However, when you look at the civil law systems, usually these systems are very strict, especially should it be found that at the time of the negotiation, certain statements were made in bad faith and the other party relied on them. In this particular instance, you may not be able to actually walk away from this negotiation, meaning that obligations have been created in the process of that particular negotiation. There's a particular principle that speaks to that, and this is the principle of culpa in contrahendo, and this particular principle provides that should a negotiation be done in bad faith in such a way that the other party is going to face negative consequences and the party has relied on what was discussed in that particular negotiation, actually to that extent you may not be able to walk away from that negotiation. And that ties back to what I started by stating, that there could be obligations a party enters into before entering into obligations. So before you commit to certain obligations, you have to be very careful about what legal system that you're actually operating in. And then, of course, finally, it is also important to pay close attention to how best you can protect yourself as you go into this negotiation. And one of the key solutions that comes out is being able to sign a non-disclosure agreement, because then that agreement can to some extent protect you from certain obligations that could have risen during the process of negotiations. Conclusively, parties do enter into certain obligations, but it is important that you could find yourself in a situation where you actually have certain obligations before you enter into obligations. So how do you then couch that particular scenario to avoid instances of liability, and how freely can you walk away from a negotiation? To what extent can you be able to do so, and also taking into consideration the country that you could be dealing with for international contracts? Is it a civil law system or a common law system, and how do they handle obligations that arise during negotiations to that particular extent?